Well, hello everyone, and welcome to the third quarter Lunch and Learn. And we are really excited that you're here today. We have a great speaker, of course, David McLean, and he is here to speak about the 2020 legislative wrap-up. But before we get into that, I want to give a few announcements in terms of what's happening here at CRG. We have another Lunch and Learn that's coming up next month, and that's going to be on fixing your business finances. How CPAs get it wrong and you can get it right. Learn 5 steps to boost profits this year, taught by a down-to-earth small business CFO. So that's coming up in October. And so look for that, save the date. It's going to be October 7th. So we hope to see you there as well. One thing before we move on with our sponsors is that we know that things have been a little crazy this year, and we thought it would be good to do a poll, just an anonymous poll, just to get a temperature on how you feel about in-person versus Zoom or online types of lunch and learn. So if you could all just get into this poll, and if you could just indicate what you're comfortable with. And again, this is all anonymous. And I think that this is important for us moving forward. This is not going to be the be-all, end-all in terms of what we're doing, but it's just good for us to get some information to see how we want to move forward. And just so you know, the next Lunch and Learn is going to be a Zoom meeting. So that one for sure is going to be online. So, okay, we've got some indications here on what's happening. Give it just another minute for those who haven't participated. Great, thank you all for participating. This is great. So really, it looks like 67% of you are comfortable, whereas about 33% are not. So thank you again for taking this brief poll. We wanted to just get an idea of how you're feeling out there. So with that, without further ado, I'm going to hand it over to Michael Beninati, and he is going to thank our sponsors. Michael?
Awesome. Thanks, Barb. I appreciate it. All right, so I'm going to run through these quickly. I think you guys that have been through this understand it, and then I will also introduce our panel. But our events do not go on without the sponsors, so I'm going to run through. We have Builders, Professional Building Materials, Colorado Cleanup Services, Ferguson BAC, Phoenix Framing, Harrison Home Systems, Materials Marketing, McClure Concrete, Boise Cascade, Owens Corning, Floor Systems, Milgard, Anchor Engineering, Genesis Roofing, Lifescape Colorado, First Integrity Title, Burnco, Westera Credit Union, Max Waste Services, Venture Painting, and some of our contributing sponsors to the event today specifically were ABC Reprographics, Blind Corners and Curves, Windermere Real Estate, New American Funding, Closet Factory, Colorado Builder, Strategic Insurance Services, and Pro Home Colorado, Wyoming. So thank you to all of you. We really appreciate it. So I got a couple bios here for our panel. So we're going to start with Terry. So Terry Pettit with Max Waste Services provides a smaller footprint, 20-yard roll-off. Yes, go ahead and wave, Terry. Dumpsters for the construction, demolition, and debris. Max Waste Services have been in business for over 50 years. So you can count on them for fast quality service for all of your smaller footprint, 20-yard roll-off needs. Thanks, Terry. Sherry Canham is account manager with First Integrity Title, has been in the title business for 20 plus years, earning a reputation of dedicated service to her clients, handling residential, lender, commercial, and builder accounts. Her focus and commitment is to being a strategic partner in all facets of the process. Thank you, Sherry. Yeah. Jim Mentor with Colorado Cleanup Services. Colorado Cleanup Services has been in business for 16 years. And they do remediation and restoration specialists with a number of builders throughout the city. They do remediation during construction and handle remediation and restoration during the warranty period. So thank you, Jim. Now, Jim will introduce today's sponsor. I'm sorry, presenter.
Thanks, Michael. I have the distinct pleasure of introducing our guest speaker today, Mr. David McLean. David is a tremendous resource and friend of CRG. In fact, I think this is his 5th or 6th time being a guest speaker for us. He's a founding member of Higgins, Hopkins, McLean, and Roswell Law Firm located here in Denver. This firm specializes in construction law and construction litigation throughout the entire state of Colorado. David has general civil litigation practice and an emphasis on the defense of complex construction lawsuits on behalf of developers, general contractors, and other construction professionals. As a result of his experience gained by defending some of Colorado's largest residential construction defects lawsuits, construction professionals seek out Mr. McLean to consult on risk avoidance and risk management strategies. In 2015, Law Week Colorado named David as the Barrister's Choice for Best Construction Defects Lawyers for Defendants. In 2019, he was recognized by that same publication as the People's Choice in the same category. David is a regular speaker at regional, local, and national seminars, including regarding construction defect litigation in Colorado. Without further ado, I'm happy to introduce our guest speaker, Mr. David McLean.
Thank you, Jim. Please let me know if you can't hear me. And it's my first time presenting on Zoom, so hopefully we'll get through this. If there are any questions as we go along, feel free to put those in the chat window, and we'll try to make this as interactive as possible. Try to make sure to ask if there are any questions as I get through it. On the legislative front, it certainly was an interesting year. By state constitution, the legislative session is only allowed to be 120 days long. Usually the session will last from beginning of January through early May, and then it's over. Because of the coronavirus this year, the legislature temporarily adjourned in mid-March, ultimately went all the way up to the Colorado Supreme Court to get some guidance as to whether the 120 days had to be consecutive or whether they could take a break during a pandemic. The Supreme Court essentially said you can take a break. So there was essentially a 2-month recess or a 2-month hiatus. And then the legislature went back in mid-May to finish up. And it was interesting. They really focused, the legislature did, when they came back into session and focused only on those things that had to be done. That included the state budget, the School Finance Act, and essentially what to do with the money that came in from the Federal CARES Act. With respect to the remaining 300 or so bills still on the calendar, the mantra was that the legislature was only going to focus on those things that were fast, free, and friendly. If it required too much hassle, if there was too much of a fight about it, they just killed it and moved on, which ultimately I think worked out in the building industry's best interest for the year. I'll focus on a couple of the bills that came up this year that would have had a dramatic effect on construction and construction litigation. Most of these died, and we'll get into the specifics. The first one was Senate Bill 138, dealing with Colorado's statute of limitation and statute of repose. Since 1986, or for the last 34 years, the statute of limitations for construction defect actions has been 2 years, with an absolute bar statute of repose at 6 years for construction defect claims. If the action came up in years 5 or 6, it got extended by 2 years. So we've always kind of referred to the statute of repose as a 6 + 2 years. But after 8 years, beyond substantial completion, construction professionals could feel somewhat safe that claims were untimely. Senate Bill 138 this year would have extended the statute of repose from 6 plus 2 years to 10 plus 2 years. So the absolute bar on construction defect claims wouldn't trigger until 12 years after substantial completion. Obviously problematic because you've extended by at least 4 years the time period that you could get sued for building. One of the things that didn't get talked about really at the legislature as this bill was being discussed was that as more and more projects in Colorado over the last decade have been built through or using RAP insurance programs, those programs, the RAP insurance policies, will typically say that the coverage remains in place for the statute of repose or 10 years, assuming that the statute of repose is not more than 10 years. So one of the consequences had this bill passed would be with that plus 2 years at the end, if claims got brought in years 11 or 12, using the RAP policies that had been in place for the last decade, there may have been no coverage available for those claims, which would have been a very bad place to be, obviously. The other aspects of House Bill or Senate Bill 138 on the statute of repose, and I don't know, you guys have heard me speak before. I kind of geek out on this stuff, and I apologize for doing it again. But this is my life. The other impact of the bill would have been to require the tolling of the statute of repose until the claimant knew not just of the physical manifestation of the defect, but also its cause. And this had been something that has been litigated a lot in Colorado over the years. When does the 6 years start to run? The statute itself says that the clock begins to run when the claimant knew or should have known of the physical manifestation of the defect, period. My window is leaking. I see the physical manifestation. The clock starts to run then. There have been a number of cases that have gone up through the appellate courts in Colorado to make that clear. Highline Village Associates versus Hirsch Companies, Colorado Court of Appeals in '99 made clear that under the contractor's statute, a claim accrues when the physical manifestation of a defect appears, even though its cause is not known at the time. United Fire Group, Court of Appeals 2010 made clear that the court found it not necessary that the homeowner or claimant know that the defect caused the fire. You need not know the cause. As long as you know the manifestation, the clock is running. And then most recently in 2017, the Court of Appeals in the Brinkman decision again found that accrual of the claim under the Construction Defect Action Reform Act depends on the discovery of the manifestation of the defect, not its cause. And the reason this is important is that it's easier to prove as a defense attorney when the manifestation occurred than it is to prove when the homeowner or an owner knew of what the cause was. You can go back into warranty logs as an example and see you were complaining of a leaky window on this date. And as a defense attorney, you can go to the court and argue they knew of the manifestation. They were making complaints of it as of this date. That's when the 6 years began to run. These claims are untimely. It's a much harder thing to prove when the homeowner knew what the cause was, that this specific piece of flashing was not there, or that the building paper was improperly integrated. And the long and the short of it is, had this bill passed and we had to prove that the homeowner knew not just of the manifestation, but also the cause, there may as well not be a statute of repose, because that's such an uphill battle to prove when they knew of the cause. The other change in this law or bill that was being considered, Senate Bill 138, had to do with equitable tolling of the statute of repose. In Colorado, prior to 2010, courts would equitably toll the statute of repose under what was referred to as the repair doctrine. And the courts would say, as long as the builder was attempting to make repairs, or if the builder had promised to make repairs, whether they were actually doing it or not, the statute of repose wouldn't start running until those efforts were completed. In 2010, the Colorado Supreme Court issued a decision in Smith versus Executive Custom Homes that essentially said the Construction Defect Action Reform Act, SDARA, provides for its own tolling. You can go into the statute and see specifically those things that will toll the running of the statute of repose. And repairs are not one of them. Promises to make repairs are not one of them. So the statute starts running at substantial completion, and it's not tolled during the pendency of repairs, during the promise to make repairs, or anything else. And Senate Bill 138 essentially would have legislatively overruled that Smith versus Executive Custom Homes case, so that you could have equitable tolling. Essentially just another reason for the owners to argue with the court that justice demands that these claims be timely, and the jury should decide it. And courts buy into that. So the Senate on second reading on the bill back in May essentially laid it over until December 31st, essentially killing the bill. This has long been discussed during legislative updates on what to expect in the future. And, I've said for years, I would expect the plaintiffs' attorneys at some point are going to take a crack at extending the statute of repose, and they've now done it. It wasn't fast, free, and friendly, and died as a result of COVID. The one good COVID death maybe we've had this year. There are a few others in here, but it's dead for this year, and I would not be surprised if it comes back next year, especially depending on what the makeup is of the state legislature after the November elections. Before I move on, let me just ask if there are any questions about Senate Bill 138 or Colorado's statute of repose.
David, I have a question. Actually, I have a couple. So what are the insurance implications if the legislature were to extend this statute of repose to 10 plus 2 years?
They would be bad. The long and the short of it is that, insurance companies set pricing by looking in the rear view mirror. What's been our loss history? How bad are we getting hit on claims? And I don't know, years ago, we tried to get a study done by DU Law School on the prevalence of construction defect cases. How many projects are being built where there's not a construction defect lawsuit, especially on the multifamily side. There are some, and if you give plaintiffs' attorneys 4 more years to go find those projects that they missed on the first go round, you're going to have more construction defect litigation, especially in cases where there's water intrusion. into the framing, where you have the potential for rotting out of materials, certainly allowing those to go on for another 4 years before the claim gets brought would make the damages worse when they are brought. It would cost more to fix them, and the size of the claims would go up. So I don't know on a percent basis what the premiums would do, but they would certainly go up. It would result in a hardening of the insurance market.
Yeah. Is this likely to resurface next year?
It wouldn't surprise me. On that laundry list of the things the plaintiff's attorneys have been griping about for years, this is certainly one of them. They always talk about the fact that Colorado's got one of the shortest statutes of repose for construction claims. I did a little research this morning online, and they're not wrong. I think that most states are somewhere between 8 and 12 years. We are on the shorter end of it. And it will be back, whether it's next year or down the road, it'll be back.
Thanks for letting me know that.
Any other questions before I move on? All right. The next one is one that we've seen before. It was Senate Bill 93, entitled the Consumer and Employee Dispute Resolution Fairness Act. And essentially this was the plaintiff's attorney's attempt this year to do away with arbitration, not just for construction claims, but really an attack on arbitration clauses across the board. Not a full frontal attack. I think it was procedural mainly in terms of making void as against public policy waivers in contracts where the homeowner in that instance would waive any objection they would have to partiality on the part of the arbitrator. Kind of hard to argue against that. You shouldn't probably be allowed to put in your contracts that any disputes will be arbitrated in front of my brother. Allowed provisions to challenge an arbitration outcome because of partiality. It established ethical standards on the part of arbitrators, and then again started including specific disclosures that would have to be made by arbitrators during the selection process. How many of these types of cases have you handled? How many cases have you arbitrated with Dave McLean or with this builder? This one, unlike past years, had some protections in there for confidentiality of information. It didn't include tell me what the outcomes were, but it certainly had kind of a chilling effect on arbitration across the board. In order to assuage fears among the building community that this was a full frontal attack on arbitration and construction claims, there was an amendment on second reading in the Senate, which would have added language essentially saying that the General Assembly declares that nothing in this act is intended to approve, disapprove, modify, or overrule the Villaggio decision, which was really the case from the Colorado Supreme Court upholding a builder's right to get these cases into arbitration. While it was nice to know that this was not a legislative overruling of Villaggio, it certainly, I think, would have had a chilling effect on arbitration, and especially if it was viewed as the camel's nose under the side of the tent. I don't think it would have ended here. I think we would have, regardless of whether it had passed, seen future attacks down the road, more taking on arbitration directly. And it's been a while, since we've tracked what the outcomes of arbitrations have been versus jury trials. I think the last time we looked at it, arbiters were awarding, just in terms of a cost of repair, maybe a third of what juries would award. Another way to look at it in a conversation we would have with our clients is, if you go into an arbitration, assuming nothing but that the arbiter will split the baby, the homeowners will have a cost of repair, will have a cost of repair, and the award is going to come in somewhere in the middle. We've had some arbitrations where, on multi-million-dollar claims, the award was within pennies of the midpoint. And while that may sound unpalatable in terms of paying more than you think is justified, it's still a better deal than what builders are getting from juries. Last time we looked at it, depending on the plaintiff's attorney and the venue, juries were awarding to homeowners or homeowners associations somewhere between 88 and 95% of everything they asked for. So if you have the chance to split the baby versus paying 95% of the claim, you split the baby. And that's why that's one of these things that the plaintiff's attorneys are going to come back to time and time again. And again, I think this is one that likely will be back. And I don't know how many folks listening read the Colorado Builder magazine, but I wrote an article, I think within this last year, talking about this situation and the legislature coming back again and again at arbitration and saying, if I were a builder now, instead of only relying on an arbitration clause in my contract, I would have discussions with my attorney or with my insurance broker about adding language now saying, if for some reason we can't get this case into arbitration, we want it decided by a judge, just a bench trial, no jury, and having an absolute waiver of jury trials in your contract should you not be able to arbitrate it. We don't have as much historic data yet on what outcomes from bench trials look like. In my opinion, they're going to be a lot closer to what arbitrations look like, since that's one person deciding it as a retired judge. I think that the results from bench trials decided by the judge only are going to look a lot more like the arbitration, and in some cases maybe better than the arbitration than would jury trials. And I say they might be better because a lot of the arbiters know that they only get paid in the future, they only get selected in the future if both sides agree to them. So if they give a builder a defense verdict or a very defense-oriented order, they're not going to get any more work in the construction world. And we've had over the years some arbiters do that, where we've gotten such a good award for the builder that we got to tell the client, like, lose their number. Nobody's ever going to agree to this arbiter again. So, they were a one-trick pony. It was a good trick. Worked out well for us in this case, and we'll never see them again. And I think because of that, in my jaded view, is why you get some of the baby splitting decisions. And you don't have to worry about that with a judge sitting on the bench. They get assigned the case, they're not vying for it. So in any event, I would consider going back and looking at contracts and making sure that if you can't get a case into arbitration, that you have a jury waiver. Before I move on from the arbitration issue, or what was this one? 138? No, Senate Bill 93. Managed to ask if there are any questions about that. It died incidentally. It was postponed indefinitely in the House Finance Committee back in June. Again, not fast, free, and friendly. Another COVID-related death.
David, I have a question about that. It sounds like you're pretty sure this is going to resurface as well. So if not next year, a year or two down the road, what do you think builders should be doing right now, I guess, to prepare for that?
Well, I think keeping up with the state of the law, and again, like I discussed, I would take a look at my contracts now. I mean, with a 6 to 8 year statute of repose, you know, the contracts that you're using today to build and sell homes are going to be litigated over the next 6 to 8 years. So I would be looking at putting in those jury waivers now, because you don't know when you're going to need it. If the legislature changes the law next year and you change your contracts next year, that's one thing. But if you don't do anything and get sued on a contract you have in place today, 8 years from now, that doesn't have that jury waiver, you may have no right to arbitrate, and you may be stuck in front of the jury paying out 95% of the claim. So this is one of those where I would work proactively. I would be changing my contract, not to account for what the law is now, but what we think the law will be at some point in the future. And then if I were a subcontractor, I would maybe want to keep my case in front of a jury, because juries don't like hitting subcontractors. So it kind of depends on what side of the bargaining table you're on, but having those discussions and being meaningful about it.
Great, thank you.
You're welcome. If there are no other questions on that, I'll move on. The next one I want to discuss.
Sorry about that. I
Barbara?
got a question in. Yeah, sorry about that. I have a question that came in on the Q&A. And it's, how has Colorado legislature attempted to force affirmative fair housing dictates on local zoning boards? So I guess, I'm sorry, it's has Colorado legislature attempted to force affirmative fair housing dictates on local zoning boards?
I don't know the answer on that. You know, most of our practice is on the back end litigation side, not the front end real estate development side. And I think, you know, that's more on the front end of the construction spectrum. And I honestly don't know the answer to that. Sorry. If somebody wants to email it to me, I'll put my email in the chat bar. Feel free to email that to me offline, and I will dig into it and get back to you. I certainly know the lawyers on that side, but anyway, sorry about that, Barbara. The next bill I want to talk about briefly also, again, died unceremoniously. This one died in the House committee on February 18th. So it was a pre-COVID death. It just didn't pass on its own merits. It was House Bill 1046, dealing with private retention reform. And the long and the short of it was that for any construction contract of at least $150,000, it put a cap on private retention at 5%. A lot of the contracts that we see in the construction world have a 10% retention. This would have capped it at 5%. Also would have included some provisions on timing of payment that may be at odds with what are in contracts today. And essentially you had to, if you were the contractor, you got paid by the owner, you had to pay your subcontractors within a month of getting paid, or within a month of the subcontractor submitting its invoice and you approving it for payment. Any downstream parties, subcontractors would have to pay downstream subcontractors or suppliers again within 30 days of being paid. And then it included an interest component. Any amounts not paid timely would bear interest at 1.5% per month until it was fully paid. And then also had an attorney's fees and costs provision in it. If you had to sue, if somebody violated the statute and you had to sue to get paid, you'd automatically get attorney's fees and costs, regardless of whether that was in the contract itself. Under Colorado law, prevailing parties in lawsuits only get attorney's fees if it's provided for in the contract or by statute. So this would have been an instance where the statute provided for attorney's fees. And if you had to sue to collect on payment, you'd have those fees paid. The other provision that I liked, and was the only part of the bill that I really did like, was that it required that any subcontractor on a project would have to submit to the general contractor and to the owner a list of the suppliers, subcontractors, and laborers who provided goods, materials, labor, or equipment to the subcontractor for the work. So in order to get the benefits of the bill, you, as the subcontractor, had to provide a list of every downstream subcontractor and supplier that was providing goods or services on that house. And I like that, not necessarily in the private retention world, but as it pertains to liens, and essentially giving the builder or the developer or the owner a list of everybody who has lien rights on a project up front, so that as you're closing out a project, you have the list of everybody you need to make sure you're getting lien waivers from. You know, I think everybody's heard the horror stories over time of going to close out a project only to find out that some second or third tier subcontractor or supplier got stiffed and is now exerting lien rights on the project, even though you've paid the prime subcontractor. And you do that because you didn't know the downstream guys were there. So this would essentially have created the list of who those potential lien claimants would be, so you can ensure they get paid. Years ago, through the Home Builders Association, I was given the uphill task of changing Colorado lien law and essentially making that a requirement of the lien law. If you wanted lien rights, you had to provide notice that you were on the job. That made it nowhere. So I did appreciate seeing that concept show up again here. This is one, it died so fast, I don't know that it will be back. You know, I think it's a favorite of the American Subcontractor Association of Colorado. Whether they take next year off or not, who knows, but I guess it wouldn't surprise me to see it back, limiting private retention at 5%. And if you get the bonus of knowing who all's on your project, may not be a bad bargain. Are there any questions on that one before I move on? All right, seeing none. Bless you, Sharon. The last one that I'll get into is one that passed, House Bill 1155. This was a bill concerning requirements that builders of new residences offer buyers options to accommodate higher efficiency devices. Under current law, a builder would have to offer a new home buyer one of the following: either a solar panel system or a solar thermal system, pre-wiring or pre-plumbing of the home to accommodate for those systems, or a chase or conduit to wire or plumb the home for those systems in the future. So within Section 2 of House Bill 1155, the legislature essentially just turned that "or" into an "and." Instead of offering one of those three, you now have to offer all three. You have to offer the solar panel system or a solar thermal system. You have to offer to pre-wire or pre-plumb the house for those systems. And you have to offer a chase or conduit to wire or plumb those systems in the future. There are some carve-out exceptions for homes constructed and already in inventory or model homes would be excluded. Manufactured homes would be excluded. And there were some other exclusions around the periphery, but it essentially makes you offer all three. As with other upgrades, you're still allowed to charge for the upgrade, offer it as an upgrade, and do it through the normal system, including overhead and profit and all of the rest of it. But those systems must be offered. The bill in Section 3 also dealt now with electric cars, so that in those same settings, if you're building and selling new homes, you have to offer one of the following: either an electric vehicle charging system, you have to offer upgrades of wiring to accommodate future installation of the charging system, or you have to offer 208 to 240 volt alternating current plug-in located in the place accessible for a motor vehicle. That one is still one of the three, not all three. And then the bill also required offering electric heating options. That was signed into law by Governor Polis the end of June. And then I was looking at kind of the effective date is triggered, 90 days after being signed, unless somebody puts an initiative on the ballot to overturn it through the ballot process. To my knowledge, there's been no challenge to it on the ballot. So I think the 91st day after signing is September 14th. So that's the one that did pass. Out of those, we were most closely watching this year. Are there any questions about 1155? All right.
We don't have anything that actually for that particular question, but I do have another question that came in. If you'd like to answer that.
Sure.
So where does insurance lobby stand?
Barbara, you're cutting out. I don't know if anybody else could hear you, but.
Can you hear me okay?
Yeah.
Okay, sorry. Where does insurance lobby stand on this pushing to their limit their liability?
Can you read that again?
Sure. It says, where does insurance lobby stand on this pushing to limit their liability? Sorry.
Oh, to the
Does that make more
carrier.
sense?
Right. No, the carriers, are always looking to limit their liability. There were a few bills that we were watching this year, with respect to carriers trying to broaden the defense of failure to cooperate by the insureds. You know, I can't think of anything that the carriers did really to restrict their liability on construction defect claims this year. You know, other than the hardening of the insurance market generally, you know, the reaction's been more on availability and pricing than the insurance industry taking a crack at anything at the legislature. I think they realize that, you know, if there's any industry that has less pull than the construction industry at the legislature, it's probably the insurance industry. So most of the reaction has been on pricing and availability. The two things that we've seen as trends in the insurance market have been on the pricing on RAP insurance programs for multifamily construction. It used to be that you would expect to pay 1% to 2% of the construction cost for the insurance program on a project, and that's now up to 3% to 4%. Last time I surveyed the brokers out there. And then with respect to the tower of insurance on any project, you know, the first million layer is not hard to get. And then the excess layer starting at 5 million, I mean, if you have a big enough project and need that much insurance, the excess layers at 5 million and above are not hard to get. The biggest trick has been finding a carrier that will insure between 1 million and 5 million. There's nobody that wants to step into that arena because they know, kind of given the size of some of the cases that are starting to come out again, you're going to get into that layer. You are going to be paying out. So that's probably the best answer I have. Nothing really as a frontal attack by the industry at the legislature, more so just in hardening of the market. You know, the carriers, I got a call last week going back, and I can't remember if it was 07 or 2010 that the legislature passed House Bill 1394, which did away with the Super Montrose endorsements. You know, Colorado looks at construction defect litigation as an ongoing and progressive loss. If I get sued today on a house I built 4 years ago, every policy I have for those 4 years are all triggered, and they all get a 25% share of the risk, and they all have to kick in 25% of the cost of settling it. Prior to 1394, carriers were using these Super Montrose endorsements, essentially saying whether you knew of the claim or not, if it started before my policy, I don't respond. So in that same situation, you could trigger the first policy, but not the second, third, or fourth. And the law in Colorado is if you don't have insurance for a loss, it's uninsured. It's on you as the builder. So the legislature, to deal with that in either 07 or 2010, I can't recall, did away with those Super Montrose endorsements, essentially said, these are void as against public policy. If you're selling insurance to builders for this risk, you have to cover that risk. Rates went up, but you also had insurance for the projects you were building. So if the insurance industry, in my mind, were to do anything, they were feeling bold enough to do anything at the legislature, I think they would start with getting those Super Montrose endorsements back. And that's certainly something we watch keenly every year and haven't seen them try yet. There are still some carriers in the E&S market that sell policies with those endorsements on them, but they're void as against public policy. I think just trying to see, can we scare somebody from making a claim by putting this on there? And they'll do that until somebody sues them for bad faith, but we'll see. The only other thing I wanted to touch on this year, and then I'll come back to see if there are any other questions, had to do with an initiative, a ballot measure, not anything at the legislature. But this thing was maybe the biggest of the good COVID deaths this year. But there's an anti-growth activist, Dan Hayes, out of Jefferson County, who was getting signatures to put this initiative 122 on the ballot in November. Had it done so, the proposal through initiative 122 was to essentially create or to limit growth along the Front Range from Colorado Springs up to Weld County, to limit growth at 1% per year, or 1.3% per year. It was 1% for most construction, then the 0.3% of additional growth that would have been allowed would have been for affordable housing or senior housing. The thing had language in there that it couldn't be rescinded until 2023, and only then by local citizen initiative. So he was out gathering signatures for that, and I think as a result of COVID-19 and the world going on lockdown, he pulled the plug on it, saying, I'm not going to get the signatures this year. It's not going to show up on the ballot. But he's not going away either. I would anticipate moving into the future that Mr. Hayes will be back with something similar to this, kind of as some broad anti-growth measure. And I think that's maybe the biggest threat to the industry that we saw this year had it gone forward. And certainly price of housing goes up, availability goes down. But that was the other thing that really came up this year that got the industry's attention and had a lot of money behind defeating it had it got onto the ballot.
David, what can we expect in next year's legislative session, and what can be done to blunt the effects of the attacks on the building industry?
I think we see some of these attacks coming back, whether it's the attack on the statute of repose, whether it's on arbitration. If I were a plaintiff's attorney, the two other things that I would be asking for would be attorney's fees paid as a matter of course in every construction defect case. Might as well put that on my wish list. And then the other one would be uncapping trouble damages under the Consumer Protection Act and getting back prejudgment interest, essentially legislatively increasing the size of the cases. So I think we're going to see some iteration of those things again next year. And then in terms of blunting the effects, you know, I'm always a big proponent of knowing your legislator, especially during the off season when they're not in session. Getting to know your legislator and meeting with them and talking with them about your business or about the industry. Not necessarily to ward off any of these things yet, but so that if these things do come up, you've got somebody who will listen. You know, and staying involved in industry groups that have a lobbying arm, I think is hugely impactful and really is the boots on the ground once the bullets start flying, so to speak, at the legislature. But I think those personal relationships are invaluable. And I had an email I still need to respond to. I'm not sure if the person's on here or not. If you are, the response is coming, but I got invited to a sit down with somebody who's likely to be elected to the legislature for next year. And it was essentially just an invite saying, hey, this is a friend of mine. She's likely to be in the legislature next year. Would you come to coffee and just talk generally about the industry and about what's going on and the history and where we are and where we're going and how that affects price and availability of homes. And I think that personal relationship is invaluable. Just flipping through the comments. Yeah, I think Stephanie Benanati remarked that it's worrisome about RAP insurance policies, that they're so expensive, and some smaller builders aren't always getting enough insurance for the size of the project. I think that's, I concur. I think that's worrisome also. Well, the biggest trick now is trying to figure out how much insurance do you need for any given project. Years ago, we had that tracked and had it pretty well bracketed. For both cases, we had arbitrated cases, we had settled cases, we saw other people settle or arbitrate. And we could say, if you are building multifamily, settlements or judgments are running $20,000 to $25,000 per door. You can multiply that out and know how much insurance you need. There's been a change in some of those cases from the plaintiff's bar, particularly Mari Perzak with Berg Simpson, who's bringing kind of the ridiculous size cases back, and they're settling for ridiculous numbers again. So if anybody's out there relying on the $20,000 to $25,000 chart we previously had out there, give me a call. We need to rethink that.
Hey, David, we have another question. And it kind of goes back to what you were talking about. It is, does HB 20-1155 apply to multifamily?
Yes. Bear with me. I'm sorry, I'm going the wrong way through my outline. Yeah, it says the requirements apply to both traditional detached single-family homes and buildings that contain owner-occupied condominium units. So, yeah, single-family, multifamily. 1155 kind of applies across the board. I had to go back and check because I was getting confused between the retention bill that died had a limit on it based on number of units, but I don't think 155 does.
Okay, great, thank you. And we also have someone that raised their hand. Chris Kramer, are you still on the phone? Do you have a question?
I'm here, but that was a mistake.
Oh, okay, not a problem.
I won't take
So
it personally.
Barb, and I know on our email, another question had come in from Emilio Ramirez wondering, what should I look for in selecting a law firm to help me understand my risk and manage it? And then the second question was, how much money should I budget for annual legal fees? He does about 4 houses a year in the 1.5 to 3 million range, primarily for spec developers.
I think on finding a law firm, I would look for one that has been in the trenches. I think that there are some firms that do the front end development work, real estate transactional work. There are some that do the back end litigation. There are some that do both. And not knowing specifically what your needs are, I as a contractor would probably want one that does both. Kills me to say that because I don't currently do both. I'm the back end litigation guy. I wouldn't hire me.
Yes.
But you want somebody that has the experience and has litigated the cases and knows what the pitfalls are, because they're better able to avoid them. And then in terms of an estimated annual legal spend, I don't know how to answer that. I think it depends on your starting point. Do you have good contracts in place? Do you have good subcontracts in place? Do you have good processes for tracking insurance certificates and those sorts of things? But I would think that once you have the processes in place and know that your contracts have been vetted and are good, you shouldn't need to be spending much with your lawyer. If everything's running smoothly on the project, there may be the odd call if there's a late payment or a missed payment, a need to extend a lien deadline or to file a lien, but that should be few and far between if you have the systems in place to avoid it.
Dave,
That's
I've
great.
got one more question for you.
Okay.
You mentioned Governor Polis and the plaintiff lawyers and stuff. As Colorado turns more and more blue, I guess where do you see our trends going in Colorado?
I think it will continue to get more and more blue. And I don't know from the building industry that that's necessarily a bad thing, right? Years ago, when we passed 1394, the legislator that came to us at the Colorado Association of Home Builders, and specifically the Construction Defect Task Force, the guy who came to us saying, what do you need to be able to build affordable housing, was a Democrat. So I don't think it's a Republican or a Democrat issue. It's finding the balance between quote unquote consumer protection. We need to protect the homeowner, but we also want affordable housing. And I think that having that pragmatic approach on what is the right balance, between we need to be able to sue you, but we also want you to build homes at an affordable price, right? You can't always get everything you want. So what is it going to be? And I think as the state becomes more and more blue, I think that affordable housing is one of the mainstays of that platform as well, right? So it's just working together to figure out how do we work together? What is the right mix? And through the Home Builders Association, when I got involved, the only lobbyist that we had at the state level was on the Republican side. And I kind of got the sense back in those days that he was effective more through fear and intimidation than consensus building. And over the years, as the state has changed, the response at the state level through the Home Builders Association has been, we should have a lobbyist on either side of the aisle. We need to be talking about these issues to everybody, because if we're only talking to Republicans, we're going to lose. So I think it's just adapting to the new mix of the state and moving through it in a very pragmatic approach.
David, is there any other questions? Any other things that we need to chat about? Our time is up. We can take another question or two. Anyone? Okay, great. Well, this will be recorded, and we will have this available for further review, or you could share it with your colleagues that may have missed it. So thank you very much. Have a wonderful day, and we'll see you at our next Lunch and Learn on October 7th.
Thanks for having me.
Okay.
Thank you, David.
Amazing job, team. Thanks a lot.